Welcome again, everybody, to my fifth case video. Wow, it's really actually hard to believe that we're on our last case video before our final project, huh? This class certainly it's flown by. I just like to say you've all done a wonderful job. I'm glad to have been working with you together this year, and I'm looking forward to seeing what your final projects will be. This will be my last video in this format, so hopefully you enjoy it, and let me know anything that I could use for my final video. With all the pleasantries out of the way, let's get started with the case of Marathon v. Blasi. Now, unlike my last case, which seemed to lack in overall background in terms of information that I could look into, this case has a lot more background that's worth looking into. And with that in mind, let's look at the players of our case. Starting off with the actress Rosa Blasi. She is a relatively unknown actor, in my opinion, but she has appeared in single episode roles of many late night shows such as Beverly Hills 90210, CSI Miami, and General Hospital. After getting a breakout role in the 2004 horror film The Grudge, Blasi enjoyed a fairly positive career, fairly ordinary career, and is currently has a recurring role on the Nickelodeon show The Thundermans, which is where she gained most of her current popularity. However, this case revolves around her involvement in the 2000 show Strong Medicine. In 1998, Blasi entered into a relationship with the talent agency Marathon Entertainment, who is the defendant in our case. Through the use of an oral contract, Blasi entered into an agreement with Marathon that would allow the company itself to serve as her personal manager. In exchange for their help in finding acting jobs, Blasi would pay them a 15% commission of her earnings that she made while under said contract with Marathon. It was actually through Marathon that Blasi landed her main role in the show Strong Medicine, which aired between the years of 2000 and 2006. However, unbeknownst to Blasi at the time, Marathon was serving as a talent agency for Blasi without having a talent agency license, which I know it's strange to think that there would be such a thing, but it exists. But still, because of Marathon's efforts, Blasi was able to gain good employment as an actress, so it seemed kind of irrelevant at the time. However, this relationship of paying the commissions between Marathon and Blasi continued like this for about 3 years. When in 2001, Blasi slowly started to cease paying the commissions that was required by her contract, and she finally ended up deciding to terminate the contract with Marathon because she was replacing them with a licensed talent agent. And as with a lot of these cases, this is where the proverbial tennis match of the law starts to go back and forth between the two parties and in between the different courts. As a result of the action that Blasi put forward, her removing herself from the contract, Marathon sued Blasi for breach of contract, false promise, and unfair business practice, which sought the return of any commission payments that she had owed them from the acting jobs that they had procured for her. Blasi responded to this suit by obtaining a stay of action, which is basically a stall of sorts that stalls court proceedings until the court decides to lift them. Blasi also petitioned during this time with the Labor Commissioner of California that Marathon had violated the Talent Agencies Act by soliciting and procuring employment for her without a valid license, which would make her contract void and allowing her to get out of it. The Talent Agency Act was passed in 1978, and it gave artists like actors and writers, it gave them the opportunity to get out of their financial obligations by claiming that their talent agents had found them work without a valid license. To this appeal, the labor commissioner agreed with her sentiments and voided her agreement with Marathon, barring the recovery of the owed commissions. And that was another thing that Marathon would eventually pull action against. Marathon appealed to the labor commissioner's decision amending its complaint to argue that the Talent Agencies Act was a violation of a manager's rights on both the state and constitutional levels. In spite of this, the trial court granted a call for summary judgment by Blasi. And for those of you who watched my last case, I explained summary judgment there. It's basically a way of settling cases outside of court because they believe that the case is so cut and dry that they don't need it, saving a lot of time and effort. However, this decision of summary judgment was reversed by the California Court of Appeals because they felt that Marathon's case to receive their commissions could be severed from any unlawful part of the agreement because the contract had been made with Blasi was lawful in purpose and had provided services to Blasi. I know that sounds kind of confusing, but to make it more clear, the term severability in terms of law refers to the provision in a contract which says that even if parts of the contract are found to be illegal, the remainder of the contract should still apply. The argument here is that even though they didn't have a license, because they had still provided the promised services to Blasi, they should still be able to redeem the commissions that they were promised. Anyway, the California Supreme Court decided to review the case at their own request. The court found themselves with overall two questions in regards to how they would figure out this case. One, does the Talent Agencies Act apply to managers as well as talent agents? And two, if that is the case, can the doctrine of severability allow for the partial enforcement of a contract when they have violated the Talent Agency Act? To answer the first question, regarding the application of the Talent Agencies Act, the court noted that the act would seem to actually strictly apply to talent agents and not necessarily to personal managers, which was what their relationship was. It wasn't a relationship between agent and actress. It was between manager and actress. So they're kind of looking for a loophole, so to speak. However, the court decided to look into the relevant wording of the act itself to find answers, starting with section 1700.5, which states, no person shall, and I use the word person in italics here, no person shall engage in or carry on the occupation of talent agency without first procuring a license from the labor commissioner. The court noted that the word person in this section is defined as any individual, company, society, firm, association, manager, a couple other things, or their agents or employees. So note that manager is actually in there somewhere. The Act also defines a talent agency as a person or corporation who engages in the procuring, offering, promising, or attempting to procure employment or engagements for an artist or artists. This led the court to reason that under the labor commissioner's decisions, because the manager, Marathon, had solicited and procured employment, the manager must be licensed under the Act. As for the second question about the application of severability, the court found that it was a little up in the air. That they did find that it did not conflict with civil code, which is where the doctrine of severability lies. However, the court could also determine that severability was equitable and fact-specific, meaning that its application could come down to interpretation of the facts. In this case, the court deferred to the discretion of the labor commissioner or the lower courts to determine if it is applicable. And that brings us to the end of our case. So in the end, what does this all mean? It means that Hollywood talent managers need to be wary of operating without a license, as the Talent Agency Act provides the talents with a way out of their financial obligations. However, they can at the very least rest assured that insulated acts of employment procurement will not void the entire agreement, and that the decision in that case will be led up to the labor commissioner. Thank you all for listening. I hope you've learned a lot, and I'll see you next week. Thank you very much.